Ms. Squally, your name, please.
I am not. Forgive me. One moment. My name is what you asked for?
I did.
No, I am not Peyton Ansley John Milton. I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
Thank you. And as to Mr. Milton, is there a competency concern, or is this
I am not represented by anybody besides myself in my sovereign capacity. Appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt. I'm letting
I read him.
Langley
I
go.
read him.
You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented. Thank you.
All right. And as the agent for Peyton Ansley John Milton, you are indicating to me that you're quite familiar with Peyton Ansley John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
All right. And you understand, for my purposes, though that language doesn't make any sense. So
no, I do not.
I understand. Okay. Well, I'm telling you that. And so I am, until you disabuse me of the motion or the notion, I am inclined to believe that you are both the agent and the person. So, and it's in all caps. I'm not a person.
I am one of the people. Thank you.
Okay. Thank you. All right. So for the record, that's my finding. Yeah, hold on. We're not done.
Okay.
Have a seat.
You got it.
And thank you. Mr. Sharp, let me swear you in. Swear the testimony and probable cause application to be the truth, whole truth, and nothing but the truth.
I so swear, Your Honor.
Okay, Mr. Sharp.
So this information comes from a report of Officer Evers of the Lacey Police Department. She writes that on March 31st this year at approximately 13:53 hours, she responded to an unwanted person complaint at a 7-Eleven store located at 2425 Marvin Road Northeast in Lacey. Dispatch advised a male was refusing to leave the store and was being disorderly, yelling at staff. Upon arriving, Officer Evers contacted staff, who advised her that it was a white male, approximately 5'5", with a beard, wearing green long-sleeved flannel. Staff advised that he was intoxicated and belligerent. They advised that at one point the male stated he would be waiting outside when they got off work. The staff advised that they asked the male to leave multiple times and he refused. They also advised that once they called the police, the male returned to his Toyota 4Runner, and the license plate is provided here, and then that it was parked outside the gas station. The staff provided a prepaid phone and a charger that the male had left on the floor inside. Staff stated that they didn't feel safe, wanted the male trespassed. Officer made contact with the male and immediately was able to identify him as Peyton Milton. Officer knows Mr. Milton is a local transient that lives out of his car, has had several social contacts with him. Officer Evers asked Mr. Milton if he was just inside the store. He stated that he was. He stated that he was too drunk to be held accountable. Officer advised Mr. Milton that he'd be trespassed from the 7-Eleven, and he stated, "I understand what you have to do." Mr. Milton offered to manually push his car to a gravel lot about 25 yards from the 7-Eleven so that he wasn't on the property since he was too intoxicated to drive. Officer agreed and gave Mr. Milton until nightfall to push the car out of the lot. Officer provided Mr. Milton with his phone, and he replied, "Can I go back in and charge it?" The officer advised him that he could not charge his phone at this 7-Eleven and that if he entered the store again, he would be arrested. Officer provided Mr. Milton with a copy of the trespass form. And then at 16:23 hours, staff called dispatch advising that Mr. Milton was back inside the store. Staff advised that Mr. Milton said he was too drunk to be held accountable, and that he left again once they called dispatch, and this time he again left his cell phone in the store. Officer then contacted Mr. Milton. He again stated that he was too drunk to be held accountable. Officer noted that Mr. Peyton was intoxicated but functional and able to understand the officer's instructions. Officer advised Mr. Milton that he was under arrest for trespass, detained him without incident. He was then booked into the county jail. Excuse me, the Squally jail.
On the charge. of criminal trespass first degree. Is the city making a motion to revoke the deferral on the assault conviction or
Yes,
on the
Your Honor.
assault case?
Based on the new law violation, yes.
Thank you. And let's see.
Will I get a moment here to articulate anything?
I'll let you know. So sit
Appreciate
tight.
it.
I'm still working through the process. Thank
Of
you.
course.
All right. So, Ms. Sharp, it appears that the assault was not a deferral. It was a stipulated order of continuance.
That's correct, Your Honor.
All right. Thank you. So we'll note the city's motion to revoke the continuance on the assault charge based on the allegation of a new law violation. And Ms. Langley was counsel of record on that case. Well, I will. And Mr. Milton is asking not to be represented by counsel. Is that correct?
That is correct, Your Honor.
Okay, so let's have a little chat about that. If you choose to represent yourself, which is your right, you can make that choice. But I want to make sure that we make a record that you are doing so knowingly and voluntarily. Ms. Langley is an attorney. I'm going to guess that you have not gone to law school and become a member of the bar. Is that correct?
I can neither confirm nor deny that information, actually.
Okay. So not being an attorney, you understand that if you represent yourself, the court cannot assist you in recognition of the fact that you're not an attorney. So you will end up missing things you're supposed to do. You will do things you're not supposed to do. And all of those things will likely work to your detriment. So it is never a smart thing to represent yourself. And frankly, if an attorney were to say they would represent themselves, I would have the same conversation with them and advise them I think it's a foolish decision to make. You, however, have that right, as I pointed out. But I want to make sure you understand you have the right to have counsel. You have the right to have me appoint counsel, or you can hire counsel. And if you ask me to appoint counsel, I can appoint counsel at no cost. So you understand all of that.
I appreciate that, and I do. Thank you.
And how do you choose to go forward?
Pro se, please.
Okay,
Your Honor.
even know the right term, okay? All right, I won't appoint counsel to represent you. You'll have to represent yourself on both cases, the criminal trespass charge and the city's request to revoke these continuance and get a conviction on the assault charge. So that's at risk here with this new allegation. So I want you to be aware of that.
Appreciate you.
And Mr. Sharp, city's position on release.
Thank you, Your Honor. I'd point out that we just resolved that other case on the 22nd of March. That was done in custody. $1,000 was the hold at that time. The city's argument for that bail was based on the nature of that case being an assault, as well as, and I think most importantly, the outstanding warrant out of Skagit Superior Court. That warrant is still active. We're here with, even more concerning circumstances now with another charge. City's request is $500 bail on each case for a total of $1,000. Law-abiding behavior, no contact with the 7-Eleven on Marvin Road, and no consumption of alcohol, marijuana, or non-prescribed drugs, nor frequenting of bars or taverns, as alcohol does appear to have been a factor in this newest case.
Thank you. And has anybody checked to see if Skagit County has been contacted regarding executing on their warrant?
I don't have any information either way on that, Your Honor.
Okay.
I believe that when, he told me, I was.
Please
Never mind.
don't allow her to speak in my stead. Thank you.
No. Okay, I'm going to ask Ms. Langley a question. Ms. Langley, what do you know about the jail's policy in that regard?
No, I only know what I learned before is that he had contacted Skagit County and they needed him to appear in person to deal with that warrant.
Okay, all right.
Your Honor, I was not read my Miranda rights this most recent time. I believe I'm supposed to request a voyeur of the body cams.
Like I said, I can't represent.
When a state introduces certified BMV records, the defendant objects, not to the evidence itself, but to the court's authority. The judge overrules the objection and moves forward. Legal procedure doesn't stop for philosophical disagreement.
You're going to have to figure all that out yourself for purposes of
Okay.
today.
I'll require 4 to 6 hours of unhindered internet access so that I can properly represent myself. If you would write that into a court
read
order.
your form on your constitutional rights.
Did I read my form? I don't believe I was provided anything.
Okay. Is there a corrections officer there?
Mr. Upton.
Yes, Your Honor.
Let's present Mr. Milton a copy of the rights form and have him read it, and then he and I can talk about it.
Yes, Your Honor. There's one taped to the desk right in front of me.
Okay. Why don't you take a minute and read it? Let me know when you're done reading it, Mr. Milton.
Appreciate you. I haven't been Mirandized, so it's hard for me to even start since I can't technically be charged with anything. And there's no victim in this alleged crime.
Okay. I know all I'm asking right now is for you to read the rights and tell me that you have done so.
All right. Would you please silence yourself? Forgive me. I have completed the reading, sir.
All right. Thank you. I'll talk about that with you in just a moment as soon as I finish this document I'm working on.
Thank you.
Any question about those rights that are on that form?
Not particularly.
Okay. Thank you. All right. So what the question before the court now is whether I'm going to hold you on bail. The city has asked for $500 cash or bond on each case. Just address that issue. Don't address the underlying facts, because to the extent that you do so, any statement you say regarding that can be used against you on these cases. So right now, just address the issue of whether you should be released or not.
Appreciate you. Yes, I would like to request being released on personal recognizance. And the reason being is because there were several things articulated in the statement that were absolutely not true. For one, I was
Hold on.
possession of a cell phone. No worries. I was not in possession of a cell phone, as I had my vehicle, my phone, my computer, my passport, and every physical possession stolen from me last time I was under arrest for defending a senior citizen in this community. The same day that Officer Tittle refused to search the man who stole my key.
Okay. Anything else?
That's it for now.
Okay.
Unless you would allow me to fill in some details that they failed to read me my Miranda rights, and I wasn't taking a statement from in both questioned cases in question. All
right. So what the case of Miranda tells us is that if you make any statements while under arrest prior to being read your Miranda rights, the prosecutor is.
After repeated jurisdiction objections, the court finds the defendant guilty. Then comes sentencing. Despite the rhetoric, the judge considers employment, jail time, and even arranges a Sunday report date to minimize job loss. Procedure prevails over protest.
Limited in its ability to present those statements to the court. It doesn't have any other purpose other than whether something you say can be used against you. That's the whole purpose of Miranda. Doesn't mean they can't go forward with a criminal charge.
Oh, I was never aware of that.
Right. Which is one of the reasons you don't want to represent yourself, but I've explained that to you now. But I just want to make sure. So you still wish to represent yourself?
Absolutely.
Okay. All right. Seem like a sharp guy, so.
Appreciate you, Your Honor.
Seem dedicated to it. Okay. Based on the outstanding warrant out of Skagit County, I will hold in $500 cash or bond bail on each case, total $1,000 cash or bond. And I'll remind you, you're to have no contact with the 7-Eleven store, no criminal law violations, not consume any alcohol and marijuana, not enter any bar or tavern. And give me some realistic expectation. Are you going to be able to post bail or likely not?
If the minimum that I'm allowed to throw on a bail is $300 and I have to bail out for two things, then I'm certain I would need to acquire a phone number that I don't have in order to make that happen. And so I would have to say that it may be closer to impossible this time around.
Okay. Well, you may know from your history that the bail here is usually 10% of what's ordered. So $50 on each case is what a bonding company would want from you. So just, I don't
Cool.
know whether that
Well, I have
changes anything.
$100. Isn't that
Okay. All right. Thank you. I will set this for 3 weeks from today at 1:30 in the afternoon. So on Monday, the 24th of April, for what we call a pretrial, Mr. Milton.
This hearing quickly shifts from traffic violations to sovereign citizen theory. The defendant argues that his all-CAPS name represents a corporation, not him, and claims the court lacks jurisdiction over the living man. The judge isn't entertaining it.